Most of this morning's testimony was about how investigators took their measurements, who did what, how they drew their maps, and so forth. And then there was the big objection. The defense wanted to prevent any evidence of presumptive tests like luminol from being admitted. They claimed it would be prejudicial and that the jury might think there was blood present in places where it had not been confirmed. The answer that I think is obvious to everyone is that the defense could simply bring out the facts if a particular stain turned out not to be blood or not to have been confirmed. So this might seem like a nuisance objection, but it's not. It's kind of a big deal. If this lawyer is successful in getting the court to grant him wholesale agreement, every lawyer is going to try and get this sort of evidence thrown out. This lawyer even cited a case. You heard that? I think we're getting thunder snow. This lawyer even cited a case in which presumptive tests were inadmissible. Now, if you heard a lawyer say, hey, there's case law in which the court ruled these presumptive tests are inadmissible, that might make a person who hasn't read the cases or doesn't follow these things come to an erroneous conclusion. Which is why you need to actually read the case law and why lawyers distinguish cases in front of the court. Anyway, the judge wasn't going to just take his word for it. He had to review the cases cited, which means that's going to take some time. So that meant a very long break. Wait until you hear what the case law actually said and what the defense tried to slip by here. Yes, I know he's doing his job, but geez Louise. I will let you hear the judge explain it because he does a better job than I would.
So in Grant, the state, or rather the court, cited State versus Schaefer, finding that it was permissible to admit into evidence the opinions and common observers, or rather of common observers in regard to common appearances, facts, and conditions. However, that testimony could not have been based on the testimony of others or some hypothetical set of facts. So the holding, as the court sees the holding in that case, is that even lay witnesses can testify as to their belief that a substance was blood, as long as that testimony is not based on what the court described as testimony of others or hypothetical statements of facts. Now, of course, in Moody, that was a situation in which expert testimony was offered. The expert witness said that a stain found on one of the defendant's shoes had given a positive result on a presumptive test for blood. In Moody, there was a presumptive test only. The court held that the result of the presumptive test for blood had no probative value whatsoever. The test result did nothing toward establishing the likelihood of the presence of human blood. In that case, there was only the presumptive test. That testimony should have been excluded and should have been found inadmissible. Now, in State versus Whipper, there was no testing at all by the police detectives. The detectives had testified that an eyewitness had seen the defendant break a vase over the victim's head. The police concluded in their testimony that the bloody hand or palm print on that vase was actually blood. An expert then testified at the same trial, and he stated that the bloody palm print on the vase was the defendant's, But he said on cross-examination that the substance on the vase had reacted to certain chemical reagents consistently with the way blood would react, but there were other substances that would have the same reaction. So because the police did not test the blood, the fingerprint expert did not test for blood, the court concluded that it was improper for the state's witnesses to testify that the palm print found on the vase had been made of blood. In Grant, that was again a recipient witness testimony. They observed what they believed to be blood and described as a trail of blood. This is another case in which you have lay people testifying about what they believe to be the substance. The court held there a person of ordinary knowledge and experience is generally competent to testify that a substance personally observed by that person appeared to be blood. Although the particular facts and circumstances surrounding the witness's observation of the substance might affect the weight to be given to the testimony, the fact that the substance was not subject to scientific testing to rule out any possibility that it was not blood does not render the testimony inadmissible. So now we come to Downing. In Downing, we had a criminologist testify, opining on the stand that they relied on a presumptive test for blood. The defendant argued that that testimony should have been precluded pursuant to Moody. In Downing, the court should say this first. This issue really comes down to what is probative. And to make it simple, is a presumptive test by itself probative? According to Moody, no, it is not probative. On that basis, it would not be admitted. The next question is a presumptive test under all circumstances not probative? The answer to that is no. In Downing, the court quotes Moody, the presumptive test for blood had no probative value whatsoever because the test did nothing toward establishing the likelihood of the presence of human blood. We're talking there about a situation in which there was no other factor to be considered. However, in Downing, the court indicated that the presumptive test, again, by itself, is not going to be probative in any degree. However, there are other factors that can be considered that would render it probative, not conclusive, but probative, such as the color of the substance, the shape of the substance, other factors that could indicate that the presumptive test could be confirmed. Now, in this case, we have a presumptive test or presumptive tests. The issue then becomes, are there other factors that can render the presumptive test not conclusive, but probative? Because relevant evidence has this definition. It's evidence that has any tendency to make a fact, the existence of a fact that is material to the determination of the matter more probable or less probable than it would be without the evidence. So in this case, you have a presumptive test by itself, not good enough, but you also have a missing person investigation. You have the color and shape of unidentified stains. You have spatter pattern. You have unidentified stains on the vehicle, in the garage, and you have an abandoned vehicle owned by Jennifer Dulos. In combination, the presumptive test is probative. The issue now goes to what weight the jury will give to the evidence. So the only danger the state can run into is if there's a question asked and the the state's witness says that presumptive test is conclusive. And remember, the court can also ask questions. So the court is going to allow the testimony concerning the presumptive test.
Just for the record, I would note that in Downing, the expert evidence showed that some of the splatter had already been tested and confirmed at the lab to be blood, not just that it looked like blood, and that's why it was allowed. But I would ask the court to address the second part of my argument, that its probative value is completely outweighed by its prejudice, especially in light of the fact there is no confirmatory tests, and that when it is tested, it is not blood. So to let it in is the equivalent of allowing, as I indicated, that rust that the jury can infer that that was blood. So I ask the court to at least address the other part of my argument.
He said splatter. It's spatter.
Well, the issue again is not prejudice, but unfair prejudice.
They argue, I could never be a judge. I'd be rolling my eyes and get myself in trouble. The judge speaks with the voice of reason. As
far as unfair prejudice is concerned, the court does not see that the prejudice is so substantial as to preclude any effective cross-examination. So the court will allow testimony concerning the presumptive test.
Then there was the whole process of the prosecutor showing the detective scene photos and asking if they were a fair and accurate representation in order to get it all admitted. It seemed like this was going to be a sleeper. Normally the defense doesn't say much about this unless they have a specific reason, but this lawyer questioned him on every single photo. Then they got to this one.
Sir, do you recognize those photographs?
Yes, I do.
Sorry. What are they?
They're photographs of the garage floor. It's 69 wells during processing.
And by during processing, is that something that you were present for?
Yes.
Okay. Did you look at those items that are depicted in those photographs? Do they fairly and accurately portray what you saw that day on May 25th, was it?
I believe these were taken on the 27th.
On May 27th, 2019, and you were present on May 27th when those photographs were taken?
Yes.
And do they fairly and accurately represent what those photographs, or what those items contained in the photographs are?
Yes.
State would offer?
And I'm going to ask you kind of the same question. When you were in the garage, did it look exactly like this with the tape measures and the other crime van measuring devices that we see in these images?
During our processing, yes, this is how it looked.
I'm sorry, would you say that again, please?
During processing, this is how it looked.
Well, I'm asking whether while you were there, were these items laid out as shown in these pictures while you were collecting evidence?
Yes.
So the two that are on the screen, which are identified as in subfile 6, garage A numbers 12 and 13, which don't appear on the sheet but are on the screen. These two show exactly how it appeared while you were in that garage.
Yes.
So the red dot on the van measuring thing was already there. Is that correct?
The red dot.
In the picture on the right, that says A17. I just want to specify which one we're looking at. That was there while you were there, correct?
Yeah, I believe so, yeah.
When you say you don't know?
I don't remember exactly what every marking looked like, but this represents two of the stains
You saw
on the garage floor.
All right, well, I get that. We've seen a lot of pictures of stains. Well, my question is, we're talking about the white metric measuring devices. You recognize those from being from the van, correct?
Correct.
So I asked you about the red dot or stain you see on the thing that's marked A17, was that there when you were in the garage? So does that fairly and accurately represent what you saw?
I don't remember that.
You do not remember that.
I don't.
And then if you look at the image on the left that has an A16 on it, you see there's also a stain on the measuring device as well. Is that correct?
Correct.
Was that there when you were present in the garage?
I don't specifically remember that.
Except for the two images on the screen, 12 and 13, I object. I don't believe this witness can categorically state that this fairly and accurately represents the way it appeared while he was present.
If I may, Your Honor, 12, and what counsel is equivocating is over a small dot on a marking tab, not even on the garage floor or a marking on the house, on the ruler that is used to delineate what I guess is a measurement system.
I'm going to object to her describing the exhibit that's not yet in evidence.
You don't have a right to argue this and admit it.
Well, the jury cannot see what this is.
That's correct.
There may be questions that the court has that will be offered outside of the presence of the jury. Because the court wants to make sure, first of all, it understands what this exhibit is on the court screen.
That's correct. Yes, sir.
So now the jury has to leave the room again. The lawyers argue, and the judge says to the defense, well, you can cross-examine on it, but, there's one more thing the defense has to try.
You can bring the jury back in.
Your Honor, before the jury comes back, there is one other issue. The court overruled the objection regarding the testimony regarding whether the reagent or presumptive, the reason for this witness's actions. But there's going to be an effort in the next 10 minutes, I assume, to try and offer, looks like, I can't tell from just the image, I'd have to call it up on the computer, 3, perhaps 4 images of somebody taking a picture with a night camera of the glow, which I submit is a separate issue of whether or not he, because I can't cross-examine the images, and I would ask that that be at least addressed outside the presence of the jury as to whether or not he was wearing, I don't know, special glasses to take the swab at the time, because the pictures are more prejudicial, in my view, unfairly prejudicial than the testimony that he did it because of the presumptive test using either the inositol or the KM.
Oh, come on. You just argued this, and the judge ruled, trying to sneak in the side door here. And the defense knows it. He even gives a little shrug at the end. You see that? They go back and forth, and finally the prosecutor calls him on it.
Your Honor, again, I feel like this is a backdoor to Your Honor's ruling already this morning that the state can offer testimony regarding the presumptive test, not only the luminol, but the KM Kastle-Meyer test. Counsel can, of course, cross-examine Detective Riley as well as any lab witnesses, present any case he wishes to do. But like Your Honor indicated earlier, it goes to its weight, not its admissibility. And this was something Your Honor decided and is allowed. So just by virtue of the fact that it's a luminol test, I don't think affects at this point its admissibility.
The court does not think this is a difficult matter to resolve. The state, of course, the state has its strategy, but the state can ask its witness, is this a conclusive test? This luminol test can show not only blood, but 30 other substances. Isn't that right? So the court sees no unfair prejudice. This is the state's presentation. The court sees no unfair prejudice. And again, the court can ask, how many substances would the luminol test detect if it is unclear? So the court sees no unfair prejudice at this stage.
Would the court at least permit short voir dire about these three images so we're not taking up time in front of the jury and then my issue is preserved for the record?
Well, the court thinks the voir dire is just as short as the court made it. This can show 30 substances, correct?
But he hasn't answered it.
Well, no, I'm not asking. Yeah. But that's as far as the court can ask that while the jury is here.
Yes, yes.
If the court is unclear.
Well, I don't even know if he was present when these pictures were taken, whether he saw it.
Well, I think that because counsel knows the case, it may be that counsel is assuming that the jury is going to draw certain conclusions, not based on what's coming in now, but based on what counsel knows about the case. If this is shown to the jury, just this photo, with some testimony as to this is what the luminol test showed, the court can see no unfair prejudice in that, and cross-examination that this isn't conclusive.
After all this, the defense still keeps trying to go at it in different ways. It's the defense that's got me wondering if all of this is more important than how it appears on the surface. I'll spare you all the back and forth, but I think you'll want to see this next little exchange.
Just to say this is the result that we saw is not prejudiced unfairly. What does it mean? That's the next question. What does it mean?
Well, is the court then to preclude that next question or wait for an objection on that? That's why we're doing this outside the presence of the jury.
Even my son, when he was a teenager, knew better not to give such a retort. The rest of the afternoon was basically going through pictures to get them admitted. So, no big bombshells. That's all I got for you today. Stay safe. I'll see you in the comments.